someone needs to look at your case really to make that determination. The next thing, and I think the part that people are most involved in is mediation, or they call it a mediated settlement conference, and it's really just mediation. Because you could, like, in a sentence, tell us what mediation is like in a North Carolina personal injury case.
So what I always tell my clients when we're getting ready for this is actually just a one-sentence phrase, is it is an informal get-together with the parties to try and come to a resolution of the conflict, oftentimes for money.
I mean, do you think that a lot of cases settle at mediation, or do you think a lot of personal injury cases settle at mediation?
Yeah, I mean, I think that the large majority of cases can, if both sides are being reasonable. Sometimes they don't, but the whole mediation process is there to try and reduce the case volumes that the court judges have to sit in front of, and I do think that when you take the mediation seriously, that it is a very valuable tool, and a lot of cases do settle that way because for one reason or another, maybe you find out at the deposition that your causation is not very strong, or it is extremely strong, and then, you know, maybe your decisions change a little bit, and the mediation gives you an opportunity to kind of go through that in a way that isn't necessarily open and close at ends. Because if you impasse at mediation, you can still go to trial. It gives you more. It still gives you options.
So I did. That brought up a good point to me. So everything that we talked about thus far, as the steps to a personal injury trial, your case can technically settle at any time, up until the time that the jury comes back with a verdict. So, I mean, I think that's important for clients and, you know, people in going through this process to understand. So being rude to or trying to bully the other side into doing what you want them to do is really not a good idea, because, you know, someone from their side has the authority to settle your case pretty much at any time. And you definitely want to keep that in the back of your mind. But going back to mediation, what is mediation like in a personal injury case? Is it everyone in the same room arguing it out, or how does it go?
Everyone will be, and Jack can help me out on this, but everyone will be in the same room for opening statements. After those opening statements, both parties will break off or divide into two sections, and then you will have a mediator. A mediator will go back and forth from the defendant side to the plaintiff side, pretty much mediating or negotiating on each party's behalf. And then at the end of the mediation, it's either yay or nay. The mediator also, if you have a really great mediator, they will also put in their feedback and their thoughts to the plaintiff or the defendant. Hey, they're doing this, they're saying this, you might want to do this, you might want to do that. Just to kind of help both parties come together to resolve the matter.
So the mediator really doesn't have, they're impartial person. So they don't have either way. It doesn't, honestly, I mean, they get paid the same for their mediating services no matter if they settle or if they do not.
Yes.
Right. And it's just, you know, so in the opening, everybody's together, and the opening is more for the benefit of the mediator, because just like you said, the mediator is impartial. They don't know who you are. They don't know anything about this case. And so the opening is each side's sort of spin on why we're here. And so the defendants may say things you don't like, and that's fine, because right after that, there's a breakout. You're in one room with your attorney, and the defendants are in their room with their attorney, and the mediator goes back and forth, and then you have your time without the defendant's, you know, snide comments or whatever about what it is that you felt about this. You get your opportunity to kind of tell the mediator why you're here, whatever that means, however long that takes, and then the mediator gets to go to the other side and hear what they have to say, and so you can get kind of a feel for where each side is and what's important to them, what's important to you, so that you can make those decisions. And the mediator is going to be just as hard on us as they're going to be on them if you have a good mediator. And it forces both sides to really look at their case and, is it as strong as I think it is? Can we really win this, or whatever? Is it worth going through all of this to win it? Maybe they're offering you a amount of money that is not what you wanted, but it's something you can live with. Those are decisions you get to make in a mediation that you wouldn't get to make in a trial.
Well, so there's some strategy, simple strategy. Don't always be the first one to put an offer out there, if you can help it, because they may offer more than what you wanted. Sometimes you can be pleasantly surprised, but that very, very rarely happens. So thank you very much for sitting in with us today and listening to our part on the personal injury trial steps. The next and last section of this is going to be about the trial itself, and stay tuned for that. Thank you. Goodbye.